How do you analyze hearsay under the federal rules on an evidence essay? Well, remember, in our last video, we said that at its core, a hearsay analysis is only two parts. Number one, is this evidence hearsay? And if so, part two, is there an exception that would allow this hearsay evidence to come into court? And remember, in our last video, we were focused on this first question. How do you determine whether evidence is hearsay? And to make that determination, we looked at the Federal Rules of Evidence, Rule 801C, where we established that there were three elements. If you had an out-of-court statement that was offered to prove the truth of the matter asserted, then we said under 801C that was hearsay, unless that statement fell under an 801D category. Because remember, I said 801D comes along after 801C and tells us even if these three elements under 801C are met, there's still some categories, some conditions that statement can fall under that are going to categorically make that statement not hearsay. So again, from a big picture perspective, you can think about 801C as telling us what hearsay is and 801D telling us what hearsay is not. And of course, all of this is still going to part one of the analysis. How do you determine whether evidence is hearsay? We have not gotten to exceptions yet, but let's go ahead and jump into 801D. And let's start with 801D2. And the reason that I want to start with 801D2 is while this rule, 801D2, is very simple, because it's very simple, it's often easily forgotten by law students. And if you forget about 801D2 and enter a hearsay analysis, it's usually going to be disaster, and I see this all the time. So I'm going to spend a lot of time droning on about 801D2 because I want this to burn into the brain of every person watching this video. I want to make sure that anybody that's watching this never forgets about 801D2 ever again, because having worked with thousands of law students over the years, I'm telling you, this is one of those ones that I just see often forgot, and it's probably because it's so simple and law professors aren't spending a lot of time on it, so we're going to spend a lot of time on it so no one forgets 801D2. Okay, so what is 801D2 all about? It's very simple. All 801D2 tells us is that an opposing party's statements that are offered against the opposing party are not hearsay. It's just one sentence. An opposing party's statements that are offered against the opposing party are not hearsay. And what's interesting about this rule, while it's simple, is that you've probably heard this rule cited several times throughout your life without ever realizing it. If you've ever watched a movie or a TV show, and there's a crime movie or a crime drama, and the police have a suspect in custody, and they're about to interrogate him, what do the police usually do? Well, they're supposed to read a suspect his Miranda rights before they conduct a custodial interrogation. And somewhere in those Miranda rights, you're going to hear a statement along the lines of, anything that you say can and will be used against you in a court of law. Well, that is directly citing 801D2. 801D2 is the reason that confessions can be used against criminal defendants. If we didn't have 801D2, think about what a confession is. Isn't a confession an out-of-court statement that's being offered to prove the truth of the matter asserted in that confession, right? Think about a confession. Well, it's happening outside the four walls of the courtroom. It's happening in a police interrogation room. It's clearly a statement, right? We have oral assertions or written assertions, and the prosecution is going to be offering a confession to show that the defendant committed the crime in question, right? They're not offering that for some other reason. They're offering it to show that the confession is true, that they committed this crime. So all three elements of 801C are met. So you would think for a second, well, isn't a confession hearsay? And if we didn't have 801D2, that would be correct. But 801D2 tells us that an opposing party's statements that are offered against the opposing party are not hearsay. And this would include confessions made during a custodial interrogation. And that's why when you read your Miranda rights, you're told this, right? You're told that any statement that you make can and will be used against you in a court of law. they're talking about 801D2. What they're basically saying is you're not going to be able to object to this interrogation for hearsay, right? You're not going to be able to do that. 801D2 lets us use this confession against you. And obviously this applies to the civil context too, right? In civil cases, if we have a plaintiff versus a defendant, right? And you always hear about this in the news, right? Think about anytime you've ever heard about somebody's social media post or a Twitter post or an email or text message coming back to bite them in the rear end in court, it's probably 801D2 happening, right? Because imagine that we have a plaintiff suing the defendant and the defendant is making all kinds of out-of-court statements. Imagine these could be oral assertions, written assertions, nonverbal assertions, doesn't matter, right? We have all kinds of out-of-court statements being made by the defendant. Well, what can the plaintiff do with these statements? The plaintiff can take these statements right here and offer them against the defendant to prove the truth of the matter asserted in these statements. So if the defendant is sending out text messages or emails or phone conversations, whatever it is, the defendant, or the plaintiff rather, can take those statements that the defendant is making and use them against him. And obviously the defendant can do the same thing to the plaintiff. Right? If the plaintiff has out-of-court statements, text messages, emails, the defendant can take those text messages, emails, whatever the out-of-court statements are, and use them against the plaintiff. It's not going to be hearsay. Under 801D2, you can use an opposing party's statements against them, right? And so important to recognize here too that it doesn't even necessarily have to be the defendant himself making the statement. We have this idea of vicarious admissions where another person's statement can be imputed onto the defendant in certain situations. The main idea we're going to have here is imagine that the defendant hires a spokesperson to speak on his behalf. So the defendant has a spokesperson and that spokesperson is making all kinds of out-of-court statements. Well, if the defendant authorized this spokesperson to speak on his behalf, we can then impute these out-of-court statements onto the defendant. And the plaintiff can use those statements against the defendant. This would also be the case in a principal-agent relationship. If the defendant is a principal and has an agent who's making out-of-court statements within the scope of the principal-agent relationship, then we can impute those agents' out-of-court statements back onto the defendant, and the plaintiff can use those statements against the defendant. This would also be true in the criminal context and conspiracy cases. So if this defendant and this defendant are co-conspirators and this out-of-court statement is made in furtherance of the conspiracy, then we can impute the co-conspirator statements back on the defendant and use it against him, right? And all of this applies both ways. So the key here to remember under 801D2 is it's a very easy rule. It's simple. It's just one sentence. But it's extremely important. Arguably the most important rule in all of evidence, at least in hearsay. This allows for so much room, right? This is the way our entire criminal justice system operates under 801D2. If we didn't have 801D2, what would the point of interrogating suspects even be, right? It would just be objected to as hearsay under 801C. 801D2 has shaped the way in civil cases, the discovery process works, and under 801D2 in the criminal context, how criminal investigations are conducted through interrogations, right? So cannot forget about 801D2. Now, obviously, the one caveat here to remember is just because a party makes a statement doesn't mean that he can introduce the statement, right? If the plaintiff has out-of-court statements, he can't introduce his own statements under 801D2. It has to be the opposing party that is being introduced the statements against, right? It has to be the defendant is using the plaintiff's statements against the plaintiff, right? The plaintiff can't introduce his own out-of-court statements under 801D2. The whole point here is the opposing party statements. Just think about the Miranda recital, right? Anything that you say can and will be used against you, right? It has to be the one side using the statements against the other side. It can't be, I said an out-of-court statement, I'm going to bring it in for myself. That doesn't work under 801D2, okay? Just one thing to recognize there. All right, so that's all with 801D2. The only thing left under 801D when we're talking about out-of-court statements that are categorically not hearsay is going to be the situation where the declarant witness has made prior statements out of court. So if we think about the policy of hearsay as a whole, why do we have hearsay? Well, one of the big reasons that we have Rule 801 to begin with is because if somebody makes an out-of-court statement, we want the party who's bringing that out-of-court statement in to call the person who made that out-of-court statement. We don't want somebody else testifying to what somebody else said. That's why we have hearsay. If somebody makes an out-of-court statement, we want you to call the person who made the out-of-court statement so they can be subject to cross-examination and speak for themselves from their own personal knowledge. We don't want another person speaking on their behalf if possible, right? That's one of the main reasons we have 801C. So 801D1 is dealing with that exact situation where the goal of hearsay is accomplished. The declarant is also the witness. The person who made the out-of-court statement has come to court and is testifying in our trial right now, right? And is subject to cross-examination. This is why we have 801. So 801D1 says if this is happening, if the goal of hearsay has been accomplished and the declarant witness is at trial testifying before us and is subject to cross-examination, then we're going to loosen the hearsay rules a little bit. We're going to say these three situations are not hearsay. Okay, so here we're dealing with prior inconsistent statements, prior consistent statements, and prior statements of identification. Okay, so let's start with prior inconsistent statements. So the timeline here is important to recognize, right? So what we're going to have is a witness or a declarant, right, who's out of court. And by the way, the declarant is the person who is making the out-of-court statement. The witness is the person who is testifying to the statement in court, right? And they can be the same person. We touched on this in the last video, but just to be clear, what's happening here under 801D1 is we have the declarant who made an out-of-court statement, and now he's in our trial right now testifying and is subject to cross-examination. So when we have this happening, a declarant who's made an out-of-court statement, who has come to court and is testifying and subject to cross-examination, we're thinking 801D1. And 801D1A deals with the situation when this out-of-court statement that the declarant made is inconsistent with what he is testifying to at trial right now. So you can imagine, declarant out of court says one thing, then he gets to court and he says something else. Well, under a prior inconsistent statement, 801D1A, we're going to say that this prior inconsistent statement, even though it's out of court, is not hearsay. And it can be introduced for substantive purposes so long as this prior inconsistent statement was made under penalty of perjury, right? If this statement right here happened in a different courtroom, right? I could draw another little courtroom. Say this happened in a courtroom where this person was under penalty of perjury. It doesn't have to be in a courtroom. Any proceeding, right? He could have been deposed under penalty of perjury. But if this declarant witness under penalty of perjury made this prior inconsistent statement and now he's testifying in court at our current trial and is subject to cross-examination, we can bring in that prior inconsistent statement to prove the truth of the matter asserted in that statement. We can bring it in for substantive purposes. Now remember, obviously in our last video, a prior inconsistent statement can always be brought in if it's being brought in for any other purpose than to prove the truth of the matter asserted. Then this third element isn't met under 801C and it's not hearsay. So if you're bringing this in to impeach the witness, you're saying, hey look, his story has changed from story A to story B. Clearly he doesn't have credibility. In that case, it doesn't matter whether or not he was under penalty of perjury when he made this prior inconsistent statement, because you're not bringing it in for substantive purposes. So that doesn't fall under 801D1A. That falls under 801C. It doesn't meet the third element, so it's not hearsay for that reason. 801D1A deals with the situation where this prior inconsistent statement was made under penalty of perjury, and now we're going to allow it to come in to prove the truth of the matter asserted for substantive purposes, okay? So that's the rule with 801D1A. 801D1B deals with prior consistent statements. So imagine that the statement made by the declarant witness out of court is now the same as what he's testifying to right now in court today. When are you allowed to do that? Well, the starting point rule here is that you're not allowed to bolster a witness's credibility. Generally speaking, you can't put on character evidence of a person's truthfulness before their credibility has been attacked. This is Rule 608 of the Federal Rules of Evidence if you want to look it up. But you'll hear this referred to as bolstering the witness, and you're generally not allowed to do it. You can't, before somebody's credibility has been attacked, you're not allowed to talk about how honest or truthful they are. So prior consistent statements is being brought on to say, hey, look, this witness, this declarant witness who's testifying is a truthful, honest person. So you're not allowed to do that until their credibility has been attacked first. So how is their credibility attacked? Well, there's two main ways here. The first one we need to talk about is when the other side is saying that this declarant witness has a specific motive to fabricate, to lie. If the other side, if another party is saying that this declarant witness cannot be trusted because he has a specific motive to lie, then that prior consistent statement is going to be allowed to come in to rebut that claim. To say, no, he's been telling the truth the whole time. Look, his statement hasn't changed from A to B. He said the exact same thing out of court as he's saying today. We're going to allow that prior consistent statement to come in. Now, there's one catch here. If a specific motive for fabrication has been alleged, if that specific motive is being alleged to have occurred before the prior consistent statement was made, then we're going to say that prior consistent statement is not allowed to come in. Obviously, right? Because the motive for the lie would have been there when the prior consistent statement was made. So if this lie happens somewhere over here before the statement was made that's consistent, we don't care because the motive to lie was there then and it's still there now. So your prior consistent statement doesn't prove anything. But if the motive to lie is alleged to have happened after the prior consistent statement was made, somewhere in this time, right, in this arrow, from the time the statement was made to before he shows up and testifies in court, then this prior consistent statement is allowed to show that he's honest, right? Because the motive to lie happened after the consistent statement was made. So he didn't have the motive to lie, and now he might, but he's giving the same story before he had the motive to lie. So it rebuts a claim that he had a reason to lie. Now, obviously, if no specific motive is given, they're just attacking the witness's credibility on other grounds, and they're not pointing to a specific motive for fabricating or lying, then you're going to be able to bring in the prior consistent statement, right? The timeline isn't going to be as important. But if they are pointing to that specific motive, you do want to look out for the timeline. All right, the only thing left to talk about under 801D, the final thing, the final situation or condition that is categorically not hearsay, is when this prior out-of-court statement made by the declarant witness was a statement of identification. So if this was a photo lineup, right, or not a photo array where a witness looks at photos and identifies a suspect, or a lineup, where the witness stands there and looks at a lineup of guys and, they do the poses and turn, and then the witness points to one of them. Those statements of identification are going to not be hearsay if the declarant witness is testifying in their current trial and is subject to cross-examination. Then those prior statements of identification are not hearsay, okay? Now, obviously, again, going back to what we started with on our 801D discussion, imagine that the police officer who was with this witness is recounting what this witness said, then 801D is not triggered, right? 801D is only triggered when the declarant and the witness are the same person. So that prior statement of identification can't be brought in if we have a police officer who is with him bringing it in. We need that declarant witness at trial, subject to cross-examination, and then the prior statement of identification is not hearsay, okay? So the main thing with 801D1 is just this idea. Think about the policy behind hearsay and this trigger event when the declarant is the witness, right? The declarant makes a prior out-of-court statement and now he shows up to court and is subject to cross-examination. We're thinking 801D1. Remember 801D2, very simple, right? But don't forget it. An opposing party's statements can be offered against the opposing party. Think back to the Miranda rights, everything we talked about. Do not want to forget this. See it forgotten all the time by law students because it's so simple. Hopefully though, remember, burn it into your brain. Never forget 801D2. But with that, guys, that's everything we need to cover to determine whether a piece of evidence is hearsay. Remember, go through your 3 elements under 801C. Is this an out-of-court statement being offered to prove the truth of the matter asserted? If it is, double check, make sure it doesn't fall under any of these conditions under 801D1 and 801D2. If you have an out-of-court statement offered to prove the truth of the matter asserted and it doesn't fall under any of these conditions, then you know it's hearsay and you're ready to move on to part 2 of your hearsay analysis. Is there an exception that allows this hearsay evidence to come into court, which is what we're going to begin talking about in our next videos. But until then, guys, I wish you all the absolute best. I hope this video was helpful and I'll see you at our next video.